at our Hot Tips program this morning, the Chief Justice of the Supreme Court of Maryland, Chief Justice Matthew Feder. Joining the Chief Justice is Wendy Karpel, who is the Division Chief of the Workers' Compensation Division of the Office of the Montgomery County Attorney's Office. And I am Michael Steinhardt, the Managing Partner of Steinhardt, Siskin & Lieberman, and the Director of the Hot Tips program. Chief Justice Feder is a graduate of the University of Virginia and Yale Law School. He served as a law clerk to Judge Leonie Brinkema, the U.S. District Court Judge in the Eastern District of Virginia, the partner in the law firm of K&L Gates LLP, before being appointed to the formerly known as the Court of Special Appeals, and in 2018, he became the Chief Judge of the Court of Special Appeals. In 2022, he was appointed as the Chief Justice of the now Maryland Supreme Court. He has served on many bar-related committees, but of special note, he has coached youth baseball, basketball, and soccer, even with his busy schedule. Chief Justice Feder, good morning, and thank you for being part of our program.
Good morning. It's a pleasure to be here.
Thank you. So I'm going to jump in and ask you the first question today, and that is, what inspired you to pursue a career in law, and what influenced your decision to do appellate work?
Well, I was an idealistic young person who wanted to make a positive difference in the world through my career choice, and I thought that the law would fulfill that for a number of reasons. One is that I do genuinely believe in the rule of law and the role that law and courts play in our society and in our way of life. I thought a career in the law could help support the fundamental underpinnings of our system of government and its promise to our citizens. Lawyers are able to help people in ways that are meaningful. Clients come to lawyers with problems, and lawyers have the tools to help them solve those problems. So I thought it would be a great thing to be part of as a way to help make the world a better place. I also had the benefit of a father who was a lawyer and a judge in Maryland, and who taught me the value of public service by just seeing how his career played out, especially through the law. So it didn't, frankly, take a lot of outside-the-box thinking for me to see how impactful a career in the law could be. I also thought a career in the law would suit my skill set, and that also helped play a part in that. As far as appellate work, I didn't initially set out to focus on appellate work. Like many of the steps in my career, that was less of a formal decision and more of happenstance. I started my career focusing on trial work. I was a litigator in the Department of Justice, and in private practice, I primarily was a trial litigator. I really only got involved in arguing one appellate case while I was in private practice before I came to the Attorney General's office in Maryland. And when I came to the Attorney General's office, I joined the Civil Division, which handled both trial and appellate work. So I immediately started handling a lot more appeals, and I really enjoyed it. I enjoyed the intellectual exercise and the time that you had. As one of my mentors in private practice told me also, that when you do appellate work, the witnesses never change their story because obviously it's all written down in the transcripts. But it was less that and more the intellectual challenge of being able to get involved in those appellate cases and get to handle some really interesting and important matters while I was at the Attorney General's office. That led me to focus more on appellate work, and that in turn led to my judicial career.
Chief Justice Feder, my name's Wendy Karpel, and it really is a pleasure to meet you and to have you participate in this discussion. Chief Judge Bell was famous for jokingly saying, "You will find no justice in the Court of Appeals." How do you feel about the change in the name of the court and the titles of the Supreme Court justices that was done in 2022?
Yes, the way I heard Chief Judge Bell say that is to lean over and when he was called justice or some other member of the court was, and he would say, "There's no justice in Maryland." So I have a few thoughts on that. One is the name of the court I previously was on, the Court of Special Appeals, frankly had to change. It was a complete misnomer. That court started by handling only criminal cases, but within a few years of it starting by the early 70s, it was the Court of General Appellate Jurisdiction in the state. So calling it the Court of Special Appeals was really misleading. So I definitely think that the name of the now Appellate Court of Maryland needed to change for the sake of people understanding really what it does and its role as the workhorse of the appellate courts handling all appeals as of right. With respect to the Supreme Court of Maryland and the former Court of Appeals, I saw both sides of that issue. There's a lot of history associated with the name Court of Appeals going back to colonial days. Most of that was very good history. On the other hand, as somebody who practiced out of state for quite a long time, I can tell you that lawyers around the rest of the country didn't know that the Court of Appeals was Maryland's court of last resort. It created some confusion, especially because Court of Appeals is the name used for the vast majority of intermediate appellate courts in the federal and state system throughout the rest of the country. So I saw both sides of that. That change was underway long before I joined the court, so I never really weighed in on it, and now is probably not the time to do that. But I will tell you that we're still getting used to the new name, and people still call us the Court of Appeals, and we still answer. As for the switch from judge to justice, that as well is one that I'm still getting used to it. Both are a bit more formal than anything I'm used to, so that of course is in accord with the titles in most of the rest of the country for similar courts.
Well, while we're talking about history, in the modern court, red robes were not worn by the Court of Appeals or Supreme Court of Maryland until 1972, and Chief Judge Robert C. Murphy was the first chief to wear them. Maryland is the only state to still wear them in modern times. Why did the Supreme Court of Maryland switch to black robes in September of 2025? And what are your feelings about the importance of the red robes or lack thereof?
So, first of all, we didn't switch completely to black robes. We still wear the red robes on ceremonial occasions, including the first day of argument of each term in September, are for bar admission ceremonies and for memorial services. We still wear the red robes for all of those occasions. For other occasions when we're sitting normally, we switched, frankly, because a majority of the court prefers black robes for one reason or another. And so now for ordinary sittings, we do wear black. But I will say that you correctly identified the history that the court didn't start wearing red robes until 1972. I think that's a ordinarily misunderstood part of the history. I think a lot of the legal community thought that we had been wearing them since colonial days, which is incorrect. The reality is, by at least the early 1800s, the court sat wearing business suits. And the court first started wearing black robes in the 1920s. And it was only in 1972 that the court moved to red. And I'll spare all the details about what got to that point. But the primary piece of evidence that convinced some on the court to agree to wear red robes in 1972 was a notation in the memoir of Chief Justice Roger B. Taney that the court was clad in scarlet on a particular day in the 1790s when he first attended the court sessions. And of course, back then, British judges changed the color of their robes seasonally, so just the fact that they might have been wearing red on that one day doesn't mean that they regularly sat in red. So the tradition of wearing red wasn't nearly as long-standing as many people thought. And as far as you also asked about the importance, I'll just say I think we've struck the right balance in keeping the red for ceremonial occasions and the black for the others. The color of the robes, of course, doesn't change the court at all, although I will say that those stocks were a little bit uncomfortable, so it's nice to not have those.
So I'm going to ask you a question, and I know all of you worked very hard on the Supreme Court, but Justice Brandeis is quoted as saying, I can do 12 months of work in 11 months, but I can't do it in 12. So the Maryland Supreme Court hears arguments from September to June. What are your thoughts about extending the calendar and hearing more cases?
I think that, what do you mean by extending the calendar?
Well, extending it from, I guess from September to June, maybe into the summer, hearing cases over the summer. Is there a reason that there's a break during that period of time?
Yeah, the reason now is so that we get all of our opinions out in the term in which we hear them, which we think is very important. The court is very committed to that. It's a change that Chief Judge Barbera put in place when she became chief back in 2013. And we are very committed to doing that. And frankly, there's really no way to do that if we don't get some time off in order to really finish those opinions and be able to circulate them so everybody can get not only their majority opinions done, but also their concurring and dissenting opinions done. We actually sit for 10 months a year, which is longer than most courts. It's longer than the United States Supreme Court. And as I understand Justice Brandeis, what he was talking about is the need to be able to step back for at least a month and regroup, which I agree is very important to be able to finish one term out and then adequately prepare for the next term. It's really important to be able to have that break. So as I understand what he was saying, he could do 12 months work in 11 months as long as he had that 1 month to regroup and prepare for the next term. But if he had the same amount of work spread over 12 months, it would not be an effective way to turn over into the next term.
So speaking about work and terms, we're going to have a new courthouse. What features, well, I guess the first thing I'm thinking of, when will it be completed? Do we have a finish date?
Yeah, so we just broke ground on the new courthouse in February of this year, and there's a 3-year timeline for the court, assuming no delays. So the current estimate is the new courthouse will be ready in January of 2029.
And what new features will it have?
Well, it'll be a modern courthouse with modern technology and security. The infrastructure will be in place to handle all current technology needs, and to the extent that we can predict them, future technology needs as well. That includes things like having good Wi-Fi throughout the courthouse, down to things like podiums that can be raised or lowered to accommodate ADA needs. And a lot of attention has been placed on security. There are a lot of features that will be taken into account, including the way traffic flows through the building, how staff and the public interact, parking, and other factors. The clerk's offices, unlike the current courthouse, will all be located on the first floor, where there'll be easier for public access. There will also be a Maryland Legal History Center that will be located on the first floor to explore how the courts and judiciary have evolved over time, and to focus on different aspects of our legal history. And of course, our great Thurgood Marshall State Law Library will also have its primary public spaces on the first floor as well. So we're really excited about that project and the opportunity to have a more appropriate home than we currently have.
Okay, and it will hold both appellate courts. Is that correct?
It'll hold both appellate courts. It'll hold the State Board of Law Examiners. It'll hold the Rules Committee. It'll hold the State Law Library and the Legal History Center. It'll hold all of that.
Okay, thank you.
I have to add to this one. For those of us who go down to argue, will there be parking for practitioners on site, or will we have to walk still?
Well, so the location of the new courthouse is actually on that parcel right adjacent to the Navy Stadium lot. So the parking will still be in the Navy Stadium lot, but whereas in the current configuration, that means you have to walk across the street by the Department of Natural Resources building and across the Tawes Garden in order to get to the courthouse. Now that parking will be directly adjacent to the courthouse, so you just have to walk over that pedestrian bridge in order to get there.
That sounds wonderful. Our next question is about security. I know you touched on it, that the new courthouse will have different traffic patterns to ensure greater security. I mean, we've had, with a judge being assassinated in October of 2023, a circuit court judge at his home. And at the Workers' Compensation Commission, they've recently added metal detectors that we all have to go through before we do our, where we used to just go right in. What can we all do, aside from, I know the courthouse is it's going to do things, but what can we all do to increase the physical security for the judiciary, both in the courthouse and outside of the courthouse?
Yeah, so thank you for talking about security. We've been doing quite a lot. We were doing a lot to work on security before Judge Wilkinson's murder, but we've been doing even more since then to make sure that our courthouses are safe as they can possibly be for everyone who enters them. That includes judges, staff, litigants, and attorneys. We don't focus on security for anybody to the exclusion of others. We've been doing a lot of work to shore up security of our court facilities across the state, including regular physical assessments of security, looking at screening policies. working on security personnel in the courtrooms. And that's a matter that the General Assembly acted on this year to identify a minimum standard for security personnel in courtrooms. And so we've been looking at this holistically to make sure that our facilities are as safe as possible. As far as what you can do or what lawyers can do, I'd really say be alert. And as they say, see something, say something. Security is really everybody's business. And we have a lot of really qualified, dedicated people who are providing security in our courthouses across the state. They respond to issues every single day to help keep everybody in there safe, but they can only do as much as they have the ability to see and to know about. So if you see something that looks funny or fishy or whatever it is, tell somebody who's in security so they can be alerted to it and make an assessment and figure out whether they need to intervene, because it really is everybody's business.
Thank
So we're
you.
going to move on, in the same vein, we're going to move on to political attacks on the judiciary. How have the recent political attacks on the judicial system impacted the Maryland judiciary? What's the impact, and what can the judiciary do to combat the criticism?
So criticism of judicial decisions is, of course, okay. There isn't anything wrong with that. People disagree with judicial decisions, and they can voice their disagreement, and that includes litigants and lawyers. That's just part of the process. But there are other forms of commentary and addressing the judiciary and decisions that take it beyond legitimate criticism. And it's particularly disturbing that there have been threats to the safety of judges and their families based on rulings. Things like that and suggestions that judges are acting with a political agenda rather than applying the law as they see it really tend to undermine faith in the judicial system as a whole. And I would say that most of the political attacks that we've been seeing are really focused more on the federal judiciary than on the state courts. But frankly, most people don't distinguish between federal and state courts or different levels of the judiciary. So yes, we see the effects of the attacks that those attacks have on public trust and confidence in the judiciary as a whole. As far as what we can do to combat the criticism, I'd say that the most fundamental thing that we as a judiciary can do is to continue to administer justice fairly and impartially, be steadfast defenders for the rule of law, and treat every single person who comes into our courthouses with dignity and respect. That is what earns the public trust and confidence in it's doing our job the best way we can possibly do it. We can also explain our rulings and reasoned opinions that people can understand, and be dedicated to excellence and a service-oriented approach to fulfilling our constitutional role. And all those things, I think, increase public trust and confidence. But one thing that is a growing topic of discussion in judiciaries across the country is what we can do increasingly to help to be out in our communities and to spread the word about what we do and what the role of the judiciary is in society so that people can understand that. Explaining what it is that judges do and what judges don't do, how we approach our cases and what limitations exist on our role as compared to the role of the political branches. I think people feel better about the judiciary when they understand more about exactly what it is that we do and what we don't or can't do. And I think we can get out and be more involved in the community and spread information about who we are and what judges do and what judges stand for. And that's something that we're working on.
Thank you.
With regards to your judicial philosophy, how do you describe it? And in answering that question, we're wondering about your approach to precedent, especially when there's a disagreement with precedent, separation of your personal political views from your legal interpretation, and what degree you give deference to legislative bodies and administrative agencies.
Well, there's a lot there. I'll try, and you can prompt me if I miss things. But as far as judicial philosophy, I don't describe myself as having a particular judicial philosophy, at least not broken down on some of the terms that are used these days as far as originalist versus positivist, all the different terms that people can use. I don't have a judicial philosophy beyond trying as hard as I can to get the right answer under the law in every case that I take. And given that all cases are different and all statutes and rules are different, that can look different in a case depending on the context and the surroundings. So I don't personally find philosophical labels to be very helpful in the interpretive exercises that we judges engage in. As I said, every statute's different, and every approach has different facts and different context. So we are really just looking to adhere to the rule of law, to apply equal justice under law, and fulfill our mission, which the stated mission of the Maryland judiciary is to provide fair, efficient, and effective justice for all. Now, you asked a number of different pieces to that as far as how we approach that. One dealt with precedent.
Yeah, how do you approach precedent with which the court now disagrees?
So precedent is precedent, whether I agree with it or not. We have traditionally adhered to the traditional approach of stare decisis, which is that we don't overturn precedent except in two circumstances. One, where it's clear that the original decision was wrong when it was decided and it's still wrong. And a second, where the intervening events or developments in the law have changed sufficiently to merit a change in the law. And those are two situations that don't happen, don't come up all that often. And that's why ordinarily we adhere to the practice of stare decisis, regardless of whether we might reach a different decision if we were hearing it on a clean slate. And that there are a number of different and important objectives that are served by that, including just the importance of people being able to rely on what the law is and make decisions in accord with that. And that counsel's adhering to that precedent, whether we would make a different decision or not. As far as, go ahead.
I was going to give you a cue. I know I put a lot in there. So how would you separate personal political views, which I think you've already touched on, from legal interpretation?
Yeah, so to me, personal political views don't come into legal interpretation at all. They're two completely different areas that really don't intersect. When I engage in legal interpretation, whether that's a statute, a rule, a regulation, or a contract, I start with the words of what it is that I'm interpreting. We have canons of construction that we rely on in order to understand what the meaning of the words are, with our ultimate goal of being to discern the intent of the body that created them, whether that's the General Assembly in case of state law, or a local legislative body for ordinances, or whatever it is. And political views are frankly irrelevant to that. That said, we all come to this business with perspectives that are built up over time based on our experience. And so I think it's incumbent on me as a judge to set aside any biases I might have based on my experience that might otherwise affect how I approach the interpretive exercise. Although I think that's a different thing than political views. We're all guided by our experience. Political views, I think, are easier to set aside than just what our experience has taught us. And that's in part because our experience, in some ways, is what brought us to the job and what led somebody to choose us to do the job. We have, all of us, background that informs how we view the world, and that informs how we view legal cases that originate in the world that we've experienced. And so in that, our experience informs our common sense, which is an important part of most interpretive exercises. And that background knowledge helps inform our sense of common sense and how we interpret things. But as a result of that, it's also very incumbent, I think, on me to try to understand what my experience has brought to my judicial role, and also what experiences I haven't had, and what experiences the people involved in the cases before me might have had that I haven't, and try to understand that in the best way I can. So I'll say I try to be as insightful as I can be about my own background and biases. I try to look at and understand all perspectives and viewpoints on an issue. And I try to be as purposeful as I can in ensuring that my interpretation is straightforward and impartial.
And to what extent should judges defer to legislative bodies? Or, we're speaking to practitioners in front of the Workers' Compensation Commission. So, in what extent should we should judges defer to the administrative agency like the commission?
So with respect to legislative bodies, I would say that judges should defer to the extent they can, which means to the extent that the legislative acts are not in violation of the Constitution or a mandate from a higher legislative body. So that's really what when we interpret, we're interpreting and trying to get really to the meaning that whatever legislative body it is was intending to give to the law or ordinance at issue. When we're then looking at whether the law that has been enacted it can be given effect, we're looking at whether it violates, in the case of the General Assembly, either the state constitution or a federal law or federal constitution. In the case of municipal bodies or counties, it's looking at whether they also conflict with state law, anything that might be higher. But other than that, if they don't conflict with a source of authority that they don't have the right to conflict with, then it's incumbent upon the judiciary to defer to those legislative bodies who are entitled under our constitutional structure to make those decisions. And our role is limited to just interpreting them. As far as administrative agencies like the commission, we also generally defer to administrative agencies other than on pure legal conclusions. We defer to the findings of fact of administrative agencies and where we look for substantial evidence in the record, and we don't reweigh that evidence. We just look to see if it exists. And it's only when it comes to legal conclusions, questions of law, that ordinarily we don't defer, because that's primarily the job of the court to have the ultimate determination as to what the requirements of the law are.
Thank you.
Now we're going back into court operations, but have there been any changes, or what changes have there been in the function of the judiciary since you became the Chief Justice? And then in that vein, what changes do you anticipate over the next year?
So I wouldn't say that there have been any broad changes to function. The function of the judiciary is the peaceful resolution of disputes. Our mission, as I mentioned before, is to provide fair, effective, and efficient justice for all. And none of that has changed. We adhere to the rule of law and aspire to equal justice under law. And all of our efforts are really geared toward that mission. But we're also engaged in a constant effort to do better for the people we serve and to deliver better value. And along those lines, since I became chief, we've completed the rollout of our electronic case management system throughout the state. That's an effort that took almost 10 years to complete, and it was a major undertaking that we finished just about 2 years ago. We have expanded the use of remote proceedings as compared to pre-COVID operations. Obviously, when I took over, we were still in, when I took my current position, we were still engaged in the effort to come back from COVID. And so we were using remote proceedings almost exclusively for some time. But now, as compared to pre-COVID days, we use remote proceedings much more than we ever used to, trying to employ it where it can be effective and most beneficial to the litigants and lawyers who appear in the courts without affecting the quality of service that we provide. We also continue to explore ways we can innovate with technology. We recently rolled out the initial steps of Maryland Online Dispute Resolution, which is now available for some traffic and small claims matters, and hopefully we'll be expanding, because that's a good service that we're very happy we can provide now. We also have engaged in some other efforts that people might be interested in hearing about. One is we've initiated a statewide effort to improve the way the justice system addresses behavioral health challenges, behavioral health issues, which I mean to include substance abuse issues and mental health challenges, permeate criminal and civil cases throughout the state. And we have been in an effort for the last couple of years to gather stakeholders from across the state to participate in an effort and see how we can do better in addressing those issues, not just within the judiciary, although certainly within the courts, but also in the other ways in which people with behavioral health issues interact with the justice system. So we held a summit last May that focused on those issues and brought stakeholders together from every county in the state and every level of government to try to see how we could do better in that area. And we now are participating in a statewide steering committee that is going to be looking on an ongoing basis of what can be done in order to improve those efforts. We also in the judiciary have been proactive in addressing artificial intelligence issues, including forming an AI governance subcommittee to address those issues and to try to educate our judges about that technology, which is really obviously has taken off tremendously since it first emerged in late 2022, and is something that is developing at faster and faster paces all the time. So we've been engaged in an effort to prepare our court system and our judges to deal with that. As we talked about earlier, we've also had a heightened focus on security issues, which has been a significant focus of mine. And I'll mention just one other thing, which is more of well, it's both a fun item as well as something that we hope enhances public trust and confidence in the courts. But my court has started sitting outside of Annapolis twice a year in either a high school or a community college around the state. We've been going through the appellate circuits in going out and doing that. And that's something that hadn't happened. The court hadn't sat outside of Annapolis since 1851 until it did so for the first time 3 years ago. And that's something that bringing oral arguments to students and communities of students around the state has been a lot of fun and really important for the court.
So you've touched on AI. I'm not going to ask you the same question, but have you seen any mistakes made by practitioners, whether they're workers' comp practitioners or other types of litigation? Have you seen mistakes in the use of AI, and what's your experience been?
So at my court, we've really seen clear evidence of AI usage only in self-represented filings on our certiorari docket. So we haven't seen it show up in briefs filed in any cases that we've taken for consideration on the merits. But we, of course, have seen all the headlines about it being used by practitioners to ill effect all across the country. I think a website that charts use of AI hallucinations in court documents has over 1,300 around the world and over 900 in this country so far. So it's something that attorneys who don't understand how it works can really fall victim to not checking work product it produces. And that's led to a lot of courts imposing a lot of significant sanctions. So AI is something I've been paying particular attention to. And I think that lawyers, as everybody, should understand that generative AI programs are truth agnostic. They're making predictions based on mathematical algorithms, not pulling from not pulling from fact. So they make mistakes. We've, as I said, seen it only in self-represented filings so far, and hopefully that continues to be the case. But we see it nationally, and to know that it's right on the doorstep.
Do you think that? Do you think still on AI? Do you think that there should be a rule on site if you're using it that you need to cite to it, or that the Rules Committee should add a Maryland rule governing AI since it has become so prevalent?
So that's something that I know the Rules Committee is continuing to look at, and that I'm continuing to think about. I'll tell you my initial view on that was no, that our current rules cover everything that is needed with respect to that. Our rules say that you can't file anything in court unless you have a good faith reason to believe that it's true and accurate. And given that we know that AI systems are truth agnostic, as I mentioned, and are making predictive decisions, spitting out tokens one by one, you cannot have a good faith belief that what AI produces is in fact accurate unless you have checked every single site yourself. So my belief initially was that our current rules cover it, and nothing more was needed. I think that we should continue to assess that, and I've continued to assess that because it's become increasingly clear that a lot of self-represented litigants and even lawyers don't understand how AI operates, and so they have been producing some materials without checking all of the sites. And so I'm open to continuing to see what comes in and to think about whether a rule is needed. But I do think that our current rules, if you understand what AI technology is, already mandate that every single citation, every fact, and every cite to a case or other authority has to be checked with human eyes before filing it if it's going to conform to what the rules require.
With regards to workers' compensation in particular, can you discuss a case that significantly shaped your views on workers' comp, and or what the most significant decision in your tenure has been on the subject of workers' compensation?
So I don't think I can point to a single case that has shaped my views more than others. I find workers' compensation to be a fascinating area of the law with a fascinating history. It really is different from most other areas of the law, just based on its, originally arising out of a grand bargain that was constitutionally suspect when it was viewed as constitutionally suspect when it was originally created, but was necessary to solve a really difficult problem that that our country was facing, frankly, and that has implications for how the system is understood. So I've enjoyed diving into the various workers' compensation cases that we've had, diving into the statutes and their background, and trying to figure out why certain things that might seem counterintuitive with respect to other areas of the law are not, and really make sense in the different contexts of workers' compensation. So I think it's a fascinating area that is fun and intellectually challenging to get involved in. And as far as the most significant decision in my tenure, I think we've only had a couple of decisions on workers' comp matters in my tenure on this court. But I guess I should really turn that question around to you as far as which are most significant, since you see the consequences of the decisions play out on a regular basis. From my perspective, every case we get is really important to somebody. And that's true of every judge on every level of the court. And that's something that I convey to all new judges when they come on board. So I don't really look at cases when we're considering them by comparing their significance to each other. And also sometimes, frankly, it's difficult to understand the consequences of a decision sort of in the long term until you see how it plays out, although we certainly try to understand what the consequences are in every single case. So I guess my bottom line is they're all really important, and we treat them that way.
I think that's a fair remark. Workers' compensation is a niche practice. How can the Workers' Compensation Bar assist the judiciary in understanding all of the nuances of the workers' compensation claims?
So I think the best advice I can give on that is to understand that judges really across the board in the state system are generalists, most of whom never handled a workers' compensation claim before going on the bench. And as you say, workers' compensation is a niche area of law where the rules aren't always the same as other areas of law, or as a judge might intuit that they should be. So I'd say first, understand your audience, and to know who it is that you're speaking to. And of course, if you're in front of a judge who has had workers' compensation experience, that can be different. But most judges haven't, or at least that experience is not very extensive before they go on the bench. So I'd suggest that the Workers' Compensation Bar keep in mind that their audience in making their cases, if you're before a judge who hasn't had a lot of workers' comp background, which would include certainly all the judges on my court, take the time to explain the background principles that are relevant to the case. Don't assume pre-existing knowledge of it. Then explain how that dispute that's at issue in your case fits within those background principles. That's very helpful at the appellate level because, again, as a niche area, the background principles aren't always the same, and judges who spent their time litigating tort matters and other cases where you can always go directly after whoever you think is most responsible for any action of negligence might not see the case in the same way. So I think practitioners sometimes have have an inclination to start in the middle of a claim, and I'll take it especially in cases that come before an appellate court. Usually the practitioner's been living with that case for quite some time and knows it inside and out and knows what all the acronyms mean, and usually the court doesn't. By the way, acronyms are one of my pet peeves. Use acronyms as little as you can possibly get away with in my mind, because they usually obscure the meaning rather than help if you're not intimately familiar with the area. But
I think
so-
we're guilty. I think workers' compensation practitioners are particularly guilty of using acronyms because we only speak in initials.
Yes, and it's certainly is not only workers' compensation practice. It's a lot of other areas as well. But when a judge isn't familiar with them, then they have to think a lot more in order to address the issue. And any time that they're wasting trying to remember what an acronym stands for is time that is brain cells being diverted from addressing and thinking about the main issue in the case. So just understand that judges are generalists and they might need a little more help than usual in addressing a niche area of law like workers' comp in just understanding what the background principles are.
Sure. Mhm. Oh, okay, sure. Okay, I'm going to go back. I'm going to do the next question. Let me see where I meet. Okay, okay, sure. All right, I'll ask the next question, then I'll mute my mic. Okay.
Do you need, Chris, do you need me to mute mine as well in between or no? Okay.
Okay. So, yeah, what suggestions do you have about preserving issues during the commission hearing and the circuit court trial for appellate review?
So my suggestions are really know the rules and make your record. And I'll emphasize the first one because you really need to know the rules about when it is that you can object to something or make your case that something should come in, when you need to make them to avoid losing them, and those can be there can be very particular and important rules. So know what the rules are for the specific proceeding you're in, and then make sure you make your record and make your record on the record. If you have an objection, know when the objection needs to be made and make it at the right time, and think about the transcript. We see cases all the time where it very well may be the case that you, the judge or commissioner, and the other counsel know exactly what you're talking about on the record, but it's never actually articulated in the transcript what it is, and so it leaves the appellate court guessing as to what might be there. So try to think about the transcript whenever it is you're making a record and make explicit what you're talking about and what your objection is or what your argument in support of something is. And that's especially the case when you might have had discussions off the record about something and then an objection is made that you need to make sure it's clear for the part that's made on the record. But basically, make sure you've read all the rules and you know the rules applicable to your particular issue, and then make your record accordingly.
To do. And what advice do you have to practitioners presenting in your court, and what mistakes do you most often see practitioners do in your court? Sure. The next question is more about what not to do. What advice do you have to practitioners presenting in your court? And particularly, what are mistakes that practitioners routinely make at the Supreme Court?
So as far as advice that I have, my overarching advice would be to be purposeful about every decision that you make. Understand that members of my court are generalists, as we mentioned before, and that none of us have had a workers' compensation background, at least not to the extent that you do. So to make sure that we understand the context and the background principles, when you brief a question before us, point us to secondary materials. We love secondary materials that give us a broad explanation of principles that help us put into context the issues that come before us. So point to those helpful secondary materials that you think might be helpful in understanding not just the particular issue that's in front of you, but also the background principles that we might need to know in order to really frame that issue, the specific dispute, in the right way. 3 mistakes that I think practitioners routinely make. One I referred to earlier, but it's starting in the middle. And what I mean by that is not giving sufficient background for us to understand how the issue you're raising comes up. We are a court that is here not to correct individual mistakes in cases, but to decide cases that are in the public interest for us to decide, that frame a rule for other courts, other commissions to apply. And because of that, our focus is on the dispute that is directly in front of us, but it's also broader in every case. We want to understand how the resolution of that case and the way we resolve it is going to impact all the other cases that are going to come after it. And so we really need to understand that bigger picture. We need to understand the context in which the issue is coming up, and that's especially the case for a niche area like workers' compensation. So I don't mean by that that you should spend every brief traversing the entire history of workers' compensation, but we need to know really the background principles that are going to be necessary for us to understand the context in which that individual dispute has come up. A second mistake that's really maybe the flip side of that is to avoid repetition in briefing. We may need you to say more than you initially would say if you're starting in the middle once, but we rarely need you to say it twice. There are too many briefs, I think, that make all of their points 3 times, that weave the legal argument into their facts and then the facts into their legal argument, and then do it again in the conclusion for good measure. And so we might not have a lot of experience in the particular area in which you're raising this, but we all read very well and don't need a lot of repetition in the materials that are filed before us. And a third mistake, which I've seen more of recently, but I'll say it's just really self-inflicted, is getting names wrong. We've had people mispronounce last names of justices, sometimes badly, mix up justices and call one justice by another justice's name, call them each other's name, and more. And the reason why I mentioned that, it's obviously not one of the biggest concerns we have, but I say it's self-inflicted because we all have the same name. It can be Your Honor, Judge, Justice, whatever it is. You don't need to try to pronounce a name or to remember a name. There are lots of substitutes that you can use and not take up any of your brain cell space trying to remember something that's not really important to your ultimate argument.
I'm surprised that one of your comments wasn't about incivility. Is that because you don't see it? And I'm hoping that's the answer.
I'd say that incivility in our courtroom is certainly, we see it a lot less than in other courtrooms across the state. We have I think overall a pretty good bar that thinks a lot about that. I think that the civility concerns are more likely to come up in trial court settings where things are, happening a lot faster and can get a bit more heated. We do see that come up in briefing sometimes, and that certainly is, it depends on how long of a list you want as far as mistakes, but it is, I don't think, ever a good idea to take shots at opposing counsel or the opposing party that are unnecessary, and they're almost always unnecessary. We don't need to hear about discovery disputes that aren't related to the issue that is before us, that just upset somebody so much that they come out when they're typing out a brief or things like that. But I'll say that by and large, the cases that come up to us, the attorneys treat them civilly and treat each other civilly, and we very much appreciate that.
Well, that leads me to oral argument and the opinions. How important, this is the question everyone wants to know, how important is oral argument?
Oral argument can be very important. There are definitely cases that get argued before us where oral argument changes minds and changes the outcome of a case. And so it's not only, I think, the most fun part of appellate law, but it is a very important part of appellate law as well. There's no doubt but that the brief is, I think, more important when it comes to ultimately what decisions are made in the vast majority of cases. Your brief is your opportunity to without interruption, identify your best case, your best case in support of your client's position. And so that then is the jump off point for all the work we do in order to get ready for oral argument. But it is absolutely the case that oral arguments can and do sway cases. Sometimes that's the answers that are given to the questions that the court asks of counsel. Sometimes it's questions that colleagues ask that point to a different way of looking at a case. But if you're told oral argument isn't important, that the decision's already been made, that is not the case. And oral argument is something that's very important to take seriously.
Well, how does the court decide which justice writes the opinion, and is the author decided before oral argument?
So the author is not decided before oral argument. The author of the opinion is decided by the senior justice in the majority who votes in the majority. So what we do is at the end of each day of hearing arguments, we retire to our conference room and we conference the cases that we heard that day, which means we go around the room and everybody weighs in and talks about the case and gives their perspective and identifies what is a preliminary vote at that point. We tally up the preliminary votes, and whoever is the senior justice in what on those preliminary votes is the majority position assigns the opinion, which means if I am in the majority on that initial vote, I assign the opinion. If I'm not, but Justice Watts is, then she assigns the opinion, and then so on. And that's decided by how many years you're on the, if you're not the chief, it's how many years you're on the court? Exactly. The most senior by definition is always the chief, and then it's just service on the court. And so that's the way that the opinions are assigned. Beyond that, we're obviously looking at making sure there's an equal workload across the court. So at the end of the year, every justice should have about the same number of opinions that they've been assigned. And that's really probably the most important aspect of that, is making sure that that stays consistent across the court.
Wendy, we have time for one more question, and that's the certiorari question. Do you want me to ask it, or do you want to ask it?
Go ahead, Michael.
Okay. So, this is the million-dollar question, Chief Justice. What is the best way, if you could tell us, to frame questions to the court to increase the chance of granting certiorari?
So I would say that the best way is to identify concisely and early why it is of public importance for my court to take the case. The standard that's identified in rule and in statute is whether it's desirable and in the public interest to take the case. And there are different ways of looking at that question, but I think the way I most frequently describe it is you're trying to make the case to us not why the decision in your case was wrong, but why there's an important legal question for this court to resolve that will have implications not just for your case, but for all the other cases down the road. We want to be able to resolve questions that are unresolved and to give guidance for the bench and the bar in whatever area of law that it is. So identify concisely and early on, ideally in the first 1 to 2 pages, why it meets that standard of it being of public importance for us to take the case. I'd also say that if there is a potential vehicle issue with the case you have, to let us know up front so that we're not surprised by it either at the end of your petition or when the response comes in. And when I say vehicle issue, what I mean by that is some issue in the case that might prevent us, or somebody might think would prevent us, from actually reaching the decision on the issue that you've presented. So if there's a preservation issue, if the other side's going to argue waiver, if there are a bunch of other messy issues that got involved that might actually be issues that we need to address first and might prevent us from reaching the really unique issue that you want to highlight, don't hide those. Let us know that it's an issue that that somebody might raise in the case, and let us know why you don't think that's an issue for us to resolve. Because it happens too often that we have a cert petition that sounds really good and that identifies a really good issue, and then we pick up a response that identifies a preservation problem that was never addressed in the petition, and we're left trying to figure out if the issue is really live or not. So that's a little bit of advice on the certiorari process.
Thank you. And Chief Justice, on behalf of Wendy, myself, and all the members of the Maryland State Bar Association and the workers' compensation community, thank you so much for spending time with us, giving us your insights, and we really appreciate it. And have a great day.
It was
Thank you very
indeed a
much.
pleasure.
I enjoyed it as well. Thank you very much, and have a great day.
You too. And if we can cut off, I have greetings for you. Chris, are you gonna? Yeah, Judge Hollander says hello. I saw her this weekend, so she wanted to make sure that I give you her greetings.
That's great. If you see her again soon, please return them from me. I always enjoy hearing from her.
She's in D.C. today. I'll call her tonight and let her know.
Chief Justice, I took some notes. I learned a lot. I really want to say I really enjoyed it, and I learned a lot. And I took notes, literally and figuratively.
Good. Thank you very much.
Right. Thanks a lot. Okay,
Thank you.
Okay, thanks a lot. Take care.
Thanks very much.
Bye-bye.